Oh, yay, oh, yay, oh, yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hibner. On behalf of Judge Stafford and Judge Bennett, we are pleased to welcome Mr. Pate and Mr. East to this live streaming oral argument. We will conduct the hearing in the same manner as if all of us were together in the courtroom. Mr. Pate will have, both sides have 15 minutes, and Mr. Pate has the right to reserve up to 5 minutes for a rebuttal, and I believe he's already done that. So unless there's announcements, we will call the case.
Tracy Marie Haltom versus Gregory Wayne Haltom.
Mr. Pate, you have the floor.
Thank you, Your Honor. May it please the court, Stephen Pate of Rutherford County Bar. I'm the attorney for the appellant Tracy Marie Haltom. This is an appeal as a matter of right from an order entered September 10th, 2019 before the Honorable Judge Rogers, Judge of the Chancery Court for Rutherford County, Tennessee. Two issues raised in my brief. The issues are as follows: whether the trial court erred in determining that transmutation had occurred regarding wife's interest in the real property located in Gallatin, Sumner County, Tennessee. The second issue is whether the trial court erred in making an equal or equitable division of the marital estate. Now, the record is rather voluminous with testimony and exhibits regarding these issues. I will not and do not have the time to go through an analysis of every piece of evidence, all testimony. The record, frankly, speaks for itself, and the brief, I think, very succinctly addresses the evidence regarding these two issues. On the first issue is whether the trial court erred in determining that transmutation had occurred regarding wife's interest in the real property. This is the property in Gallatin, Sumner County, Tennessee, that wife owned in fee simple prior to the parties' marriage. So there's no issue. It was a separate property. The value as stipulated by the parties upon the sale of same was $102,000. And that equity upon the sale of same was invested in the parties' property, which the first property they owned together in Readable, Rutherford County, Tennessee. Again, there's no issue that that money was the wife's money from the wife's equity from wife's separate property invested in the Readable property. Now, the court found that those funds had been transmutated, I should say, even though it was from her separate property, by the purchase of the property in Readable, Tennessee. And therefore, obviously, that presumptively vested the husband with 1/2 of those funds. Respectfully, we're arguing that the trial court erred in determining that wife transmuted these funds because, one, the wife testified and the husband basically acquiesced that notwithstanding that payment of the property into Readable and the Readable property being deeded to both parties as tenants by the entirety, that thereafter, one, the wife was exclusively responsible for making the mortgage payments on that property, exclusively responsible for utilities, for upkeep, for general taxes, and husband, by his own admission, made almost no contribution to that property. Literally none, even though as a surgical assistant, his income was right at $80,000 per year. He just simply relied upon the wife paying for that property.
Did she have a separate bank account that she used to pay these expenses?
Yes. Well, at one point she had a separate account, yes. And at one point, I think they had a joint account. At one point, I'd have to refer to the record to determine exactly when that occurred.
When she had the separate account, was she using earnings to pay these expenses?
She was using, yes, sir, her earnings, and she had a substantial income to pay these expenses. But if I recall, husband had a separate account and he was using his expenses to pay his own personal expenses, his truck payment, for example, his child support from a child from another relationship. Basically, he put no effort or no money into this property. Literally none. And the court—
Does that make any difference when his name was placed on the deed?
Well, I think it does if you can basically trace back the funds. There's two cases in support of my theory. It's the Treadwell versus Lamb case, as cited. The Treadwell case is the 1917 Court of Appeals. Hunt versus Carden, 2020 Court of Appeals, and said if you can trace back those funds and determine where the funds came from exactly, then basically it's not necessary to determine sort of presumptively that there's transmutation. If you read those two cases, the court basically held, in fact, similar to the instant facts, that in fact, by tracing back the funds, the wife can be awarded her share. I mean, basically the funds that she put into the property. In Treadwell, for example, they determined that it was a jointly owned property, but they still allowed the husband to retain his separate money he placed into the property simply because you're able to trace it back. And so, ironically,
let me ask you a question, counsel.
Yes, sir.
What was the reasoning then, if these parties were attempting to maintain this separate property, for, as Judge Bennett just asked, the name being placed on the deed?
Well, she testified as to that exact issue. She literally said, I did it to preserve the marriage. The marriage was apparently had trouble from the beginning, and she was trying to preserve the marriage. And she placed the property on the deed simply to help preserve the marriage. Well, it failed regardless.
And do these two cases that you're relying on have that kind of fact situation in it?
Facts, yes, sir. Very analogous facts. Two cases, recent cases that support our position. That if you, yes, sir.
By that I mean, as to your client's position that I was attempting to preserve the marriage, that reasoning as to adding the name to the deed.
I can't say that those cases do. No, sir.
Okay. You seen any cases that do in fact do that? Because it seems like, what's the old adage, having your cake and eating it too. I want to preserve my separate property, but I also want to do this to make somebody happy. Well,
I know those are unique facts and certainly unique to the instant case. And I can't say the two cases I have cited support that or rely upon those exact facts. No, sir, I can't say that, but it at least relies upon, it's supporting of the theory that, again, if you can trace back the funds, you can basically award, in this case, the wife, her interest in her former separate property. Now,
well, I understand that you can, but the question is, should you? Because it appears that it was a deliberate decision on the part of your client to say, I'm going to do this, for her reason being a good reason in her mind, but yet then attempting to change her position at this point in time and say, but I want to keep it separate too.
I understand. That's what she did. I'm not saying it's the most logical position, but I understand it was, in her mind, logical. She wanted to preserve the marriage and just put it in and deeded it to parties jointly.
I understand, but it puts us in somewhat of a quandary.
I understand. Yes, sir. And like I said, some of these facts are difficult. But somewhat ironically, in this spreadsheet that we have attached as part of our brief, the property in Readable, Tennessee that has now been sold, that property only had equity upon the sale of $79,351. Well, she put $102,000 into the property, but with the market being what it was, it sold for only $79,000. The old court order that equity to be divided equally. The wife is asking, obviously, that she be awarded the $79,351 because it's more than $20,000 less than the price, the funds she put into it. Again, thereafter, the husband making no contribution to the preservation of the property or to the improvement of the property. It lost value somehow. So she's asking for that money back. And again, you've got to consider by statute, obviously, each party's contribution to the purchase of the property, each party's contribution to the preservation or to the improvement of the property. And the record is replete. He did literally nothing. He cut the grass, and that is about it. And she did everything financially and physically for the improvement, for the maintenance. I mean, his position was he lived there, had the full benefit of it, but put no money, no time, no labor, no effort into the maintenance or improvement of the property.
So it was that's the property that was the marital home.
I'm sorry, say it again, sir.
That's the property that was the marital home then?
Yes, sir. The Readable property, this Readable, Tennessee is, actually I said Rutherford, I think that's Cannon County, Readable, Tennessee. That was the marital home wherein the parties resided until they separated, and that's a new issue. The wife's testimony was the parties really stopped having a marriage in January of 17. They stopped sleeping together. They stopped basically acting as husband and wife because the husband had a girlfriend in another county and was seeing her. They didn't physically separate until September of 17. But in January 17, they started conducting everything separately, including sleeping apart in the same residence. But the Readable, Tennessee was the first marital residence where the parties resided together. Sumner County is where the wife owned her home, obviously pre-marriage, and that's where that equity of $102,000 came from. If you have other questions on this issue, I'll be happy to address it before I move on to the second issue.
There was another parcel of property, right?
Other personal property?
No,
Parcel.
parcel of property.
Yes, sir. There's a cabin. There's property referred to as a cabin that the parties purchased. She purchased the land, and then they built a cabin. It's a weekend retreat cabin, and it's referred to in the brief. It's referred to largely as the cabin.
They built the cabin, you said?
I'm sorry?
You said they built the cabin?
Well, she bought the land, and then while they were married, the cabin was built. But sort of analogous to my other argument, he basically contributed no money to the purchase or the building of the cabin. It was her money for the building of the cabin. Thereafter, her money for the improvements of the cabin, her money for the maintenance of the cabin. And she testified at length and had her own sort of spreadsheet that as best she could say, I mean, I think he put in some track lighting and cut grass there. And the little track lighting was a couple of $1,000s. She estimated, this is part of the record, that at the extreme, he contributed $25,000 to the equity in the cabin. She contributed the $75,000 to the majority of the work. The equity in the cabin was $100,000 as stipulated. So therefore, the court ordered that the equity, that she would owe him $50,000 because she's keeping the cabin. The cabin still exists. It's a weekend retreat. The court ordered that therefore she must pay him $50,000 for one half of the equity in the cabin. Her position is he should be entitled to a maximum of $25,000, which is 1/4 of the value of the cabin. And he testified literally that she was responsible for the big ticket items for both the home and Readable and the cabin. All of the big ticket items, the mortgage, the insurance, the taxes, the maintenance, the improvement, and he just basically paid for the little items, including the purchase of groceries. And so that is, yeah. So again, there's no question that while that's the only real property left of the marriage, that the husband's contribution by statute falls far short of anything approaching equal. And it's so clear. She's saying that the only equitable division of that is approximately $25,000. And she testified that's on the high side. But she's asking to maintain the cabin and the equity therein, except she would owe husband $25,000 for his equity in the cabin. And not being overly critical with Judge Rogers, but at the end of the case, I mean, there was no analysis, there was no breakdown. It was just everything was equally divided. And by statute, you have to look at each party's contribution and some reasoning for that equal division. So in Judge Rogers' mind, equal was equitable. And our position was, no, sir, equal in this case was not equitable.
All right. Thank you, Mr. Pate. Your time is up, but you'll have more time for rebuttal.
Yes, sir.
East.
Good morning. Before I begin into my argument, I want to correct a few things that I think Mr. Pate, after hearing me correct these factual issues, will agree with me. It has been some time since Mr. Pate and I presented this case in front of Judge Rogers, and I can understand why he maybe wasn't exactly correct on a few of his numbers here. When the house in Reedville was sold, it was sold by agreement of the parties. We were going through a divorce, and it was sold and recognized approximately $180,000, not the $79,000 that ultimately was held by Mr. Pate. It recognized approximately $180,000. And what we did by agreement, both Mr. Pate and myself, on behalf of our clients, we agreed to use some of that equity that was recognized to pay off a few things. And that's how you got down to the $79,000 that at the time of trial was actually being held in Mr. Pate's escrow account. The things that we paid off that kind of ran it down by about $90,000 or $100,000 included things like joint taxes that the parties owed for a few years prior. It paid off the remainder of the mortgage that existed on the cabin property that he references there. There was a mortgage on it. It was used to pay that off. It also paid down some debt that the parties had on an HVAC unit that was necessary for the improvement of this cabin property. And so at the time, although Mr. Pate said, hey, well, she put in 102, his words, not mine, she put in $102,000, and it only generated at the sale 79 is factually incorrect. Number two, let me correct something on the cabin property. Mr. Pate stated repeatedly that she bought the cabin. While in fact, and I think the court and the trial court recognized my client's testimony over his, they bought the cabin. They bought it during the marriage. They bought it after the parties had jointly selected this cabin. This cabin was jointly titled in both of their names. This cabin was jointly financed in both of their names. The cabin was a fixer-upper. And so after buying this property, Mr. Pate's client and my client proceeded to make significant improvements to this cabin. It was going to be a weekend place that both of them could enjoy. They essentially took what was a lean-to storage building and outfitted it into a livable space. And they testified, both of them testified, that they themselves did things like flooring and lighting and all kinds of different upgrades there. They subcontracted some of it out, but most of it they did themselves. They did this on with the help of her family some, but mainly those two. And so again, respectfully, I would disagree with Mr. Pate. And I'll say this, whatever payment was put down on that cabin property as well was also done from joint funds. One of your honors mentioned and asked Mr. Pate, and I think it's a very important part, is that Mr. Pate, throughout his brief and through his argument today, talks about how his client paid for X, when in fact what had happened was his client may have written the check. However, it was used, the funds used were not from separate property. Most of these funds throughout the course of their 14-year marriage, these funds were marital funds. They were funds that were created during their employ. Now, after correcting those two factual issues, I'll go to kind of my substance of my response to Mr. Pate and his position on this. As I see it, Mr. Pate is essentially trying to do this. He has spent the trial court's time trying to discredit and diminish my client's contribution to a 14-year marriage. My client, contrary to his client's testimony, testified that he did, in fact, contribute substantially to this marriage. And I think it shows by the length of time that these parties were married that my client did, in fact, contribute. Now, it is undisputed that Mr. Pate's client, throughout the entirety of their marriage, made more money. And therefore, many of the larger scale bills were paid essentially by her, through her, etc. But that does not and was not the testimony of the parties. My client did, in fact, contribute substantially, not only financially, but emotionally and what have you in this marriage to have had it last this long. Now, what did my client do? My client did pay for some of the lesser included expenses. He testified that, yes, some of these smaller ticket items were my responsibility because she was carrying the larger scale bills. He testified that he helped with her children at times, that there were times where, because he had the more flexible schedule and she had the larger income producing job, that he shouldered not only the responsibilities of him and her, but also some of the responsibilities that she had with her children at the time. That he maintained the properties. You'll see, if your honors will look into the transcript, that my client, they had a tractor essentially at the marital property in Readable, that my client, until he got hurt, was solely responsible for maintaining this acreage. This wasn't just a house in a neighborhood. This was, in fact, my client was responsible for doing all of those types of things. Now, she may discredit it, not think it's worth as much as what she did, which was writing generally the mortgage. But my client did, in fact, contribute to not only this house, but the house before. My client even quit his job at the behest of Mr. Pate's client. Essentially, both of these parties were working very jobs that demanded a lot. And at the time, my client, during this course of this marriage, was making more money because he was working he was working on some shifts that didn't give him the flexibility, essentially, to manage the day-to-days that she needed, because she was having to travel and work longer hours, et cetera. And so they made, as a joint couple, a decision for him to take a lesser job where he could work as needed, so as to continue and work through this marriage that certainly had its challenges through the time. Now, they were married, and I could understand if this was a 1 or 2 year marriage, but your honors, this was a 14-year marriage by the time Judge Rogers heard this matter. He noted, the court noted, that these parties were both hardworking people that essentially made joint decisions throughout this marriage as to how this marriage was going to be handled, who was going to pay what, who was going to work where they were going to live, what they were going to do with their free time, how they were going to vacation. My client made joint decisions on both of those properties as to the property in the cabin, as well as the property in Readable. My client did repairs at all of those properties, including the property there in Gallatin. My client handled a lot of the maintenance that was involved in those things because, again, Mr. Pate's client was working a lot. My client involved himself in the building process to help do this. And I think your honors hit the nail on the head when, and I had it noted that if it wasn't brought up on Mr. Pate's argument, that I was going to say it, that she admitted when asked, why did you make these decisions to buy these properties with a husband of 10 plus years? Why did you include him on the deed? And why did you jointly finance it with him? Both properties jointly financed. They used his credit to qualify for these. And she said, I did it to save the marriage, right? And so it's not even like she could claim ignorance that, hey, I didn't realize this was what was happening. The title company made us put these names on the properties. I thought I'd still have some claim to it. No, she understood what she was doing when she did it. And she did it because they were having, at that point, a 10-year marriage that they were moving forward with, that they were buying larger properties with, and they were selecting together. So, of course, she understood what she was doing. They were working, as most married couples do, is together making joint decisions. And what Mr. Pate's going to continue to go back to is she made more money, and she contributed more financially, and therefore she deserves more of what the marital funds ended up being at the time of the divorce. And respectfully to Mr. Pate, that's just not what the law is. And that's not what Judge Rogers determined to be the correct distribution of these assets. And I'd say one other thing, and then obviously if there are any questions, I'm happy to answer them. If Mr. Pate's client, who is very sophisticated, who is certainly capable of handling a big job with larger demands, et cetera, if she thought all along her intention was to keep these things separate, she could have gotten a prenup, She could have gotten a post nup. She could have written out some other deal. She could have kept these things in her own name. She could have refused to jointly finance, refused to put them in both names, and she frankly did not. And what she did is she waited till the end of the divorce when it was clear that obviously the marriage needed to end, and she tried to essentially pull back and recreate what the agreements were between the parties. And ultimately, Judge Rogers listened to both our clients and determined that no, these were joint decisions. Mr. Pate and his client were not able to rebut the presumable presumption that these were marital property. And if you look at it, we meet all those tests. The use of the property by the family to support the marriage. One, we hit that. Number two, shared control, maintenance, and management of the property. We hit that. Three, titling the property jointly. We hit that. Four, use of the non-owner spouse, if we weren't an owner, which we were, but even whether our credit was used to essentially secure these assets. And it was. And so
Counsel, let me ask you a question, please. You've gone through the factors there. Did the trial court analyze those factors as well and make those findings?
I don't think he's, and I've read it, so I know Judge Rogers did not specifically go 1, 2, 3, and 4, Your Honor. But if you read his ruling and if you look at it, he made the very clear finding that this was marital property, that it was their intent to have, that it was jointly titled, that they jointly shared in these decisions. And so although he didn't maybe call out, as I do in my brief, the Luplow versus Luplow decision, that's what I'm referring to here. He did, in his ruling, hit those factors very clearly and made a decision that this has been transmuted property.
Okay, and let me go to the second part of that question is opposing counsel has suggested that the trial court simply determined that equal was equitable. Was there any analysis made as to that determination?
Yes, Judge. I think that him acknowledging that there was no dissipation of assets, that they equally contributed to this marriage, although their incomes were never identical, that they were equally contributing to the marriage. I think very, very much so explains and solidifies his decision to keep this equal. I would argue, Judge, and we certainly didn't do this, but given the facts and the earning capacities of the parties, et cetera, that my client could have come in there and asked for some type of spousal support. Now, we didn't. Wasn't our intention to. Our intention all along was, hey, split this up equally. You know, our marriage started on this day, ended on this day. Let's get it done. But I think that an equitable decision, if you look at it, could have fallen farther in my client's favor because of earning capacity and some separate property that we acknowledged right from the beginning was hers and hers alone, that we weren't going to fight about because it was very clear it was separate property. So if that analysis had been done, I think equitable actually would have tilted to our favor, not to Mr. Pate's favor, as he's arguing today.
You've got just a little time left. Do you want to say anything about the retirement and investment accounts?
The retirement accounts unequivocally were earned during the marriage. Mr. Pate made an argument that, hey, essentially January of 2017 should have been the date that those things were valued. Simply put, that is not the agreement. That's not the law. And these parties continued to work on their marriage all the way up through the fall of 17 and ultimately didn't get divorced until 19. And so Your Honor the trial court made the correct decision in valuing those things as of the date of the divorce. And that's where we are here today.
All right. Anything further, Mr. East?
No, Your Honors. Thank you.
Thank you for your argument. We'll hear from Mr. Pate on rebuttal.
Yes, sir. Thank you. Very briefly, coincidentally, based on the last issue Your Honor raised, I have raised that same issue in issue number 2, and that is TCA 364121C to determine the equitable interest of each party in the marital estate. The statute quotes the contribution of each party to the acquisition, preservation, appreciation, and depreciation or dissipation of the marital or separate property. Respectfully, this is further in my brief, that the trial court did not give any consideration, at least on the record, as to those specific factors when making an equitable distribution of the marital estate, did not make any specific findings as to how to weigh same, and simply resulted in an equal division of the marital estate with no specificity as to what factors favor an equal division of the marital estate. I'm not faulting Judge Rogers any further, but if you look at the statute carefully, you look at his ruling, the ruling fails to follow the statute to determine each party's, again, acquisition, preservation, appreciation of the marital estate. You just simply can't ascertain or determine what factors the court was relying upon in his final valuation equal division of the marital estate. And I think that was respectfully in error.
All right. Thank you, Mr. Pate and Mr. East, for your arguments. We will take this matter under advisement. Mr. Hivner?
The honorable court is now in recess until 10 a.m.